Good morning. It's Aaron Levine from LG Insurance, and I'm here with our friend and great Monmouth County attorney, Julia Dasaro. Welcome. Thanks for hanging out with me today.
Thanks for having me, Aaron.
I wanted to ask you a quick question. You know, recently we just did a life insurance policy for a divorcee.
Okay.
Right? She had a judgment, a big document for that divorce. How does court go about figuring out what life insurance should be purchased for the husband and for the wife, and, you know, how does that all get figured out?
Well, depending upon how the case was resolved, whether it was actually a trial or an agreement between the parties, the court may or may not have had any input on that. Mm-hmm. In an agreement, the court generally doesn't put their 2 cents in, so to speak. Right. If the case is tried and a judge then makes the determination, then the court would make those factors. But either way, they would use the same type of a formula. And that would be to look at whether or not there were spousal support obligations and child support obligations, and then try to determine the amount of that obligation for the number of years it's going to be in effect, and come up with an amount from there. So by way of example, if you had a spouse who would be paying a spousal support obligation of $50,000 per year over the course of 10 years, generally, we would say, okay, well, that person needs a $500,000 life insurance policy so that in the event something happened to him or her during that 10-year period of time, the money for the balance of the spousal support obligation would be available. Okay. With a child support obligation, generally both parties are required to have insurance, whether it be the spouse who's paying child support or the spouse who's receiving child support. Because even if you're receiving spousal support, you're still being assigned a certain portion of the support obligation. Right. So the receiver would be a lesser amount of support, and the payer would be a higher amount of support. And there again, you would say how old are the children, how many more years until they're emancipated under the emancipation law, and whether or not there are other assets available for paying for their college, other education, and things like that. So, you know, you would base it off of the child support award, and extrapolate it out from there.
What if one of the parties is not in great health? How does the court make a determination in that case?
Well, that's a difficult issue that does arise sometimes. And generally, the courts don't pay much attention to that. They just say it's your responsibility and your obligation somehow to get this insurance. And that's where, as attorneys, we turn to people like you, Aaron, to say, okay, help us out here. I've got someone who has a history of a heart attack or, a cancer diagnosis that they've now recovered from. But, knowing that underwriting will still look at that as an issue, how are we going to get this person insured? Right. So that there's the insurance available.
And what if there's already life insurance in place prior to the divorce? Is that acceptable, or?
That can be acceptable. It can be factored in if it's not enough, but it can be assigned as a portion of it, so long as the proper people are named as beneficiaries. Okay. And then in general, what we would do is say that every year the party should provide evidence that the insurance that is there is still in effect and that the right people are beneficiaries. Okay.
So the moral of the story is get your life insurance before you get sick and before you get divorced. It seems like it's going to be a lot easier to do it that way.
Absolutely.
Thanks, Julia, for joining us this morning.
No problem. Thank you.